Sorry?
My people, all eager. Shall we start? Yes? Yes, people? Okay, awesome. Hello. Okay, hello. Hello. Welcome. You can hear me, right? Rosanna, can you hear us? Okay, awesome. Hello, welcome. Thank you all for being here, for making it this far along the first day. I will start by introducing our panel. First, the ones on site, and then the one that is joining us online. So we have Taner Kuru, who is a PhD researcher at Tilburg University, and his research focuses on ethical and legal implications of AI-driven genetic research. He holds an advanced LLM degree in law and digital technologies from Leiden University, and he recently received the European Data Protection Law Review's Young Scholars Award for his article on genetic data that he will also be explaining more later in the session. We have Ella Jabukowska, who is leading EDRI's policy work on facial recognition biometrics from state and private actors, and also she has been working on also different policy actions on the e-privacy regulation, the PROM2 proposal for law enforcement exchange of information. She has been involved also leading the Reclaim Your Face campaign to ban biometric mass surveillance. And finally, joining us online, we have Rosanna Ducato, who is a lecturer of IT law and regulation at the University of Aberdeen. And she's also a research fellow at the UC Louvain. And her research oscillates between privacy and data protection and intellectual property law. And finally, myself. I am Alexandra Genopoulou. I'm a researcher at the Institute for Information Law at the University of Amsterdam. And my research area is digital identity. And I organized this panel also with my co-lead on this project, who could not make it here unexpectedly, Amade Mcharek. She is a professor of anthropology at the Department of Anthropology at the University of Amsterdam, and her research interests are in forensics, forensic anthropology, and race. And finally, very recently, she was awarded the prestigious ERC Advanced grant with her projects on forensics and migration. So the particularity of this panel is that because Amade could not make it, I will abuse a little bit of my moderator role, and this is why I'm sitting on the panelist table and not over there. So I will play a double role, presenting our project and participating in the discussion, but also asking the questions. So I will try to not abuse too much, but try to fill a little bit the role that Amade was supposed to have on this panel. So, abusing my moderator role, I will start. I will give a brief introduction of the topic and the issue before giving the microphone to the panelists for their opening statements. So we started this project, this interdisciplinary work with Amade at the University of Amsterdam, trying to research specifically digital identities and digital identity infrastructures when they operate on a global scale. And we chose this example of genomic identities as identities that do have all these features, and they are representative of the variety and diversity of risks that can be present on all and many levels, well beyond the legal and privacy and data protection realm. And specifically, we chose the case study of what has been named as investigative genetic genealogy, which is the use of commercial genealogical DNA databanks that are stemming from predominantly US-based private companies. So the use of these databanks by different law enforcement from various places of the world, not only in the US, but also in the EU and other places. And we wanted to investigate and articulate how first there is they represent this rapid rise and intensive use of digital identities on the core level, that is our biometric identifiers, but also the way that these digital identities are progressively and very intensely being commodified, and how these commodified identities actually end up full circle again back in the hands of the state and the implications thereof. So the questions that we wanted to ask when starting this project is what are the risks in making available to law enforcement privately created and maintained DNA databases, and in general genomic profiling that is happening from these companies. We wanted to interrogate what types of cases and under what contexts these collaborations happen, and also to see whether these collaborations happen to be acontextual, or what are the criteria used by different law enforcement agencies or by the private companies themselves into deciding what types of cases they are going to pursue. And what are the frictions that are created there? In order to do that, and because of the lack of information from all types of actors, we decided from a methodological perspective to pursue expert interviews and to approach all different types of involved actors. So we started talking to different private companies that are in the forensics and genomics and DTC market, so direct-to-consumer genomics market. We also talked to law enforcement, traditional forensics investigation people, and also public actors, ministry officials, judges, etc. And this is still an ongoing process. So this is we have definitely not reached our final findings, but we do already have some preliminary ideas of how what are the issues or the main patterns that are emerging through our discussions with all these people. And so within this context, I invited this group of panelists to discuss from different perspectives, legal and policy, on how we address, how we protect, and what are the blind spots of the legal protections that are currently in place in addressing these rapidly rising and very profitable digital identity global markets. And so with this, I would like to give the floor to Tanner first for your opening statements, and then we'll continue. Thank you.
Well, thank you so much, and thank you all for being here. Well, I think, start with a disclaimer. Like, although it's very nice back in person events, I totally forgotten how exhausting it can be. So if I don't, and as you can see, the weather is not helping too. But it gives kind of like a dramatic vibe also. So relates to also our content. So yeah, as previously stated by you, despite the many controversies around surrounding their use, these commercial databases have been used by law enforcement officers, and we should acknowledge that DNA evidence and genetic information are very essential tools for law enforcement in their effort of fighting against crime. But of course, because of that, it's no surprise that they have an interest in these genealogical databases. And of course, even before this expansion, they had been benefiting from DNA evidence in their efforts, in their practices. And because of that, and thanks to that, we have more or less of an established case law regarding DNA retention by law enforcement, etc. And that usually comes from the Strasbourg Court, the European Court of Human Rights. But as we see, in fact, these principles and safeguards somehow codified in the EU framework, and that is mostly given by the fact that Law Enforcement Directive specifies that processing of genetic data to uniquely identify a natural person is prohibited unless certain conditions are met. This new practice is challenging this framework because law enforcement are not the ones who are actually collecting the samples anymore, but they benefit from the already existing databases that are created by these market players. So this is a game changer in a way. Although, as I said, we have expansive and extensive regulations when it comes to forensic databases, the same, unfortunately, cannot be said for these newly established genetic databases or biobanks, however you call it. And that is mostly coming from the efforts of direct-to-customer genetic testing services. But nevertheless, fortunately, we have GDPR still applies to their practices. But I'm not sure what is the cohort today. But given this is the CPDP, I'm not going to go into the details of how GDPR actually regulates the processing of genetic data. But as a crash course, we can say that because of its sensitivity, it's listed among one of the special categories of personal data, and because of that, its processing is subjected to a stricter regime compared to other types of personal data. And of course, member states can further introduce some derogations or limitations or other kind of principles to processing of genetic data as well. But one thing, because of that, also what we see is often these companies that are creating these databases usually rely on explicit consent because of the processing grounds of for the legal basis. But one thing makes the processing of genetic data is very special here, and it is kind of stand out, but apart from the other ones, other type of personal data. And that is when we look into our genes, it doesn't reveal information about only ourselves, but also about other individuals with whom we share the same or similar genetic makeup. And because of that, of course, like what it means, then the processing affects not only those individuals and the donors, let's say, in this context, but also their genetic relatives. And because of that, of course, when we give access to law enforcement to these databases, the infringements or discriminatory effect could also born into those individuals beyond these donors. So this makes, of course, things complicated. And we might, because of that, need to look further than the individualistic and binary protection scope of the GDPR. And it was also discussed in one of the earlier panels. But and that is because we might give some type of protection to these individuals within the GDPR, within the data protection framework. But according to my research, I should say that I'm not quite optimistic about this interpretation, and I can talk about further why in the following rounds.
Thank you. Ella? Thank you.
Thank you. Hi, I'm Ella Jakubowska from European Digital Rights, here as a token civil society person on this panel. I'm really grateful to be here. A laugh was maybe not what I was expecting when I said that. So one of the topics on which I work is what we have called biometric mass surveillance. So that's things like facial recognition in public spaces. And we've been very vocal as a civil society coalition in calling for a complete ban on these kind of uses of biometric data that would amount to mass surveillance. And a lot of that is to do with the fact that these systems, these practices can identify and profile people immediately and at scale whilst they're trying to go about their lives and the exercise of their rights. And so we haven't tended to look as much at genetic data, but actually what we're starting to see is maybe more of a convergence in the biometric surveillance space with forms of genetic data. To give one example, we're seeing research coming out around breath print identification. So you breathe into some sort of device to be identified, and that's being done under the banner of biometric data, but actually you can see how genetic data could actually be provided through that process. So I think we see those kinds of examples and a lot of other ways in which genetic data and biometric data have these similarities. Again, the sensitivity under GDPR and law enforcement directive is something that these forms of data share. And in our work against biometric mass surveillance, there's a number of kind of key points that I think are also very salient to the issue of commercial genetic databases and their use by law enforcement. One of them is the idea of how biometric surveillance turns each of us into a walking barcode. That's been something that we've campaigned a lot against. And I think there's a very similar idea there when we think of genetics. We've focused a lot on the inability to truly give genuine, meaningful, and informed consent to biometric surveillance in public spaces. And we've also focused a lot on the underlying infrastructures and the databases that really enable a lot of these practices that we are fighting against. So I want to talk a little bit about the PROM2 Regulation, which is one of the EU files on which I work, and I think it brings together some of these issues quite nicely. So PROM2 was proposed at the end of last year by the European Commission, and it's a legislative proposal that would modernize a pair of decisions from some rules from 2008, which govern the sharing of DNA and fingerprints between EU member states and certain third countries. But the modernization, I'll say that in inverted commas, that has been put forward by the Commission is really, really concerning for us. They want to further automate a lot of the processes. And in our analysis, really what that means is removing safeguards in the sharing of these very personal data, so DNA being genetic and fingerprints being biometric. There's an interesting twist that they're also doing on the definitions of biometric and genetic data, because under the PROM2 proposal, DNA profiles are actually considered biometric data, as are facial images. And for kind of any other biometrics nerds, you might recall that in the GDPR, facial images only become biometric data when they've undergone specific technical processing, whereas under PROM2, just facial images per se become biometric data. I'm not sure yet if that actually helps us, seeing as the protections that are put forward in this law are really, really weak, but still it's an interesting point. And beyond this, the PROM2 regulation wants to add facial images to this automatic exchange. It wants to add police records, so not just criminal records, but police records about hearsay and other things, other notes that police officers might have written without any recourse to kind of any sort of judicial verification. And there's even a push from the Council of Member States, if they get their way, then the biometric and biographical information of all driving license holders would also be included in this expansion of the PROM framework for data sharing. And some other kind of facets of the PROM2 framework are that about half of EU member states right now don't have mass facial image databases that would allow them to participate in this data sharing. And so the European Commission proposes that this could be partially funded from the EU budget. And thanks to a Freedom of Information request that was done by one of my colleagues, we know that there are intentions to do relative DNA searches through the PROM2 framework, what they refer to as kinship analysis already being done in some member states, not legal in all of them. So PROM2 would also set up this automated searching for unknown persons to be identified on the basis of relatives' DNA. And kind of in my work on this file, I've started to wonder whether we have some sort of natural association with DNA being linked to criminal procedure. We see on TV all the time, TV shows where cases are solved by a magical piece of DNA, and that we somehow collectively imagine that DNA is fair game in a way that helps other forms of surveillance to be smuggled in. So this PROM2 proposal that I've just been talking about has received very, very little legislative attention. The consultation on it had 6 inputs, and you compare that to something like the AI Act, on which I also work, on facial recognition, which had over 1,000 inputs to the consultation. So, you know, and because PROM is already established as a way of sharing DNA, it's been put forward by the member states that it's not controversial to just add in facial images. It's not controversial to add in driving licenses. But I do want to kind of make a point that I guess in my perspective, the police use of commercial databases is not necessarily any better or any worse than police's own databases. The PROM framework is based on national databases where we followed really systemic issues, serious discrimination, a lot of people wrongfully being included in these databases. To give just 2 examples, there's the Alien database in the Netherlands, which is a pseudo-criminal database, and the people who are in it, it's used as a criminal database, but the people who are in it, their crime is being foreign. There's the Taj database in France, which is used for criminal investigations, but it contains 8 million facial images. You know, so when you think about the proportionality and the vast number of people that are in there and have had facial recognition applied to them through this. So to kind of wrap it up, I just want to give one example from the biometrics context, but I think it could be helpful for also thinking about the genetic context, which is going to the Netherlands again, the Camera in Focus project, which is a program which allows citizens, residents, and businesses to share their CCTV feeds with law enforcement for purposes including so that this footage can have their catch facial recognition algorithms applied to it. So it's already a kind of privatized, or kind of individualized form of surveillance. But it doesn't stop there. Businesses that are enrolling their cameras into the system, they can actually go for a free health check for their surveillance cameras. The police will very kindly tell them about the quality of their feed. And once you've gone through this check, your camera is automatically added into the Camera in Focus program. But don't worry, because it specifically says that if you're worried that your surveillance footage might be infringing on EU law, this project is not intended to enforce data protection and privacy laws. So you don't have to worry if you're doing something wrong. They also, under this project, gave 360 residents free Amazon Ring doorbells so that they could connect those doorbells. You probably won't be surprised to hear that if you got a free doorbell, it was also automatically enrolled in the Camera in Focus program. And 87.6% of those doorbells were found to be at least partially covering the public space. So I think this is a really good example of how these private, public-private interfaces can start leading to forms of de facto mass surveillance. The Dutch police said that program was making the streets safer without any evidence. And I would hope that we might not see these same forms of mass surveillance when it comes to genetics, that would be too sci-fi. But then I look at the EU's data strategy, for example, where the idea of data altruism is being put front and center, that we should all be good citizens, make our data available for the common good, and I'm maybe slightly less optimistic. So, thank you for letting me share that apocalyptic talk to go with the apocalyptic weather.
And we're going to move on to Rosanna now.
Yes, thank you, Alexandra. I'm going to have the classical Zoom experience here for a number of reasons. Well, first of all, the first one is the most obvious one, so I'm joining you through Zoom, and the second one is that I cannot see you, so I'm talking to a black screen in front of me, so it's like I'm giving a class to my students. So, coming now to my opening statement. I think that the use of commercial DNA databases for law enforcement purposes, what is being called investigative genetic genealogy, presents, as also the other speakers have said, several problematic aspects. First of all, the sector is largely unregulated, and at least in Europe, I think that a public-private partnership like the one that we are discussing today would face a number of issues from a legal point of view, in premise, if we consider the data protection domain. Later on in the discussion, we will probably enter into these details. But what I would like to say is that even if we solve all the data protection questions and we regulate the use of commercial DNA databases for law enforcement purposes, I wonder whether that would be enough, whether that would answer a fundamental question. So what kind of systems are we going to create, and what would be the implications of adding a commercial actor into a law enforcement mechanism? What would be the implication for the society as a whole? So this collective dimension that also Tanner was mentioning earlier. We have to be mindful that these databases were created and they are almost used as a hobby. So they use genetics to help people reconstruct their family tree, essentially. Then they were acquired or worked in partnership with private actors who developed commercial services on top of them. Now, these companies are private actors, so they physiologically pursue an economic interest, and their actions are driven by commercial choices, including the customer preferences. On the contrary, forensic investigations are driven by a completely different aim. So there is an underlying tension in this kind of context that, in my opinion, should deserve a careful consideration. So kudos, Alexandra, for organizing this panel and start discussing the points.
Thank you very much. I wanted to pick from, so I have several questions and threads I want to pick, but I wanted to start by the consent that you mentioned, because this has been something that is one of the main recurring discussions that I have had throughout all these interviews, where when discussing, the compliance or even kind of ethical justifications for these processes, the answer that I would get is, well, if you consent to being included in that database that would be queried by the law enforcement, then, what is the problem? And why wouldn't that be, an issue of the individual agency of the person? So I wanted to ask you, Tanner, to unpack a little bit more the collective aspect of genetic data, and vis-a-vis also any collective protections that you think might exist in the GDPR, affecting more than the individual that the sample belongs to, that does the consenting.
Yeah. Well, of course, there might be some ways to include these people into the protection scope of the GDPR. And first and foremost, how we can provide someone with protection if we consider them as data subject that provides a full and effective protection. And indeed, the GDPR might allow such interpretation, given the definitions of the notions of personal data, data subject thereof, and genetic data. And what we see is actually the CJUs have a broad interpretation already existing in this domain. For instance, according to the recent case law from the CJU, it says that the personal data relates to an individual if it's related to by its content, purpose, and impact. And actually, in this very context, we have the most obvious examples. Let's take, for instance, the impact one, because by the way, those are not cumulative. Just one of them could be enough to satisfy this criterion. And let's say by the impact, actually the very let's say your sister's genetic data has been processed in this regard, and the impact being is you're getting arrested. So of course, you have this impact here as one of the most obvious one. And the second one, of course, this is not enough. We have to also look at the identified or identifiable criterion. And voila, we have again one of the most obvious examples here, because the very purpose of law enforcement is actually behind the DNA evidence or genetic information is to identify you or build a kinship here between the crime scene DNA or whatever DNA evidence that they have at hand. So, but of course, I mean, here we need to consider, like, you know, okay, like they can be data subjects, yes, and because of that we can provide these people with protection. And it was also discussed, as I said, in one of the earlier panels too. But then I think we also need to look at the consequences of this interpretation. And that's why I said that I'm not quite optimistic about this one, because the practical consequences might be very severe when it comes to data protection framework, because it's very individualistic and it has a binary structure, which I mean by binary and individualistic structure. When we think about personal data processing, we have one data controller and one data subject, and the whole relationship is actually established between these two. But when we introduce biological relatives here, actually we're actually crashing down the whole system, so it might not work. So for instance, if we consider here the biological relatives of the donors or whoever shares this genetic data with these private companies as data subjects here, what if the biological relatives, or like genetic relatives, however you call them, try to exercise their data subject rights because they're entitled to do so? Then how we can actually conciliate the rights and benefits and interests is like clashing, like the data subject, the donor, or the data subject as the biological family member, the data controller, society in general, because then we also have public interest here, both in healthcare and security sectors. So, but the GDPR doesn't provide any kind of guidance here how to solve when we have clashing rights over the same personal data by different data subjects, because it wasn't created by this idea in mind. It's very individualistic. But of course, this is an interpretation, and it can be argued otherwise too, and there are also ways to accommodate this, as it was suggested. But I'm afraid in these kind of situations, the first solution could be, and you can find these provisions in the GDPR too, there are many derogations for derogation opportunities for member states when it comes to processing genetic data. I think usually what would happen is that maybe we can derogate some of these data subject rights that we provided these people in order to give them protection. So it's kind of dichotomy for me. It doesn't make that much of a sense. And I think although there might be a solution which could appear as doing a balancing test, but I'm not quite sure about practical consequences too, because as we all know how enforcement of GDPR is going on. So I think, again, like this is a hypothetical scenario, and we don't know yet how the CJU would interpret such a case, whether they would consider genetic data processed here, the personal data of the biological family members, or they come up with a total different system. We're introducing as, and also suggested by some of the authors that, hey, these people are secondary data subjects and stuff, but it also creates a bit of a mess because how you can accommodate such a new interpretation here. So I'm sorry for this like catastrophicated scenario affected by the weather too. And Paul was saying it's a sunny weather, so I mean, that's kind of surprising. But this unsolved issue, of course, doesn't create problems only within the data protection framework, but unfortunately also in law enforcement directive too. And I would like to mention and underline this last and crucial point before actually providing my answer. And this is because law enforcement directive has more or less the same definitions for genetic data, personal data, data subject, etc. And for example, I will read this article for you to also understand like what is the problem here. So according to Article 10 of Law Enforcement Directive, processing of genetic data for the purpose of uniquely identifying a natural person, which is exactly what we're talking about today, shall be allowed only where strictly necessary and subject to appropriate safeguards for the rights and freedom of the data subject. Who is data subject here? That we don't know. And only A, where authorized by union and member state law. That is quite tricky. B, to protect vital interests of the data subject or of another natural person. Again, we have kind of an amalgamation here. And the last one, it goes as where such processing relates to data which are manifestly made public by the data subject. So do you see the problem here? So the last one is a problematic one, because let's assume, and maybe we can also introduce here at a certain point the golden state killer case, which is the infamous one. But let's assume that your sister took a direct-to-customer genetic test and uploaded her results into this like JET match like database or just published on social media to find some support groups for the hereditary disease that revealed by that genetic testing, or just for fun. Does that mean here, by doing so, your sister actually made this data publicly available, manifested publicly available? Because it also affects on you too here, so we need to find a legal basis here, right? So does that also mean that your genetic data is now available and accessible by law enforcement too? Like, does that mean that we actually in practice have a legal basis that is hidden here by law enforcement to use this databases? So, and if so, if we actually identify you as data subject here, would our answers change, and how we can accommodate all those like conflicting rights here? So I think these unsolved like issues here makes the regulation of law enforcement access to these private databases quite problematic. And unfortunately, I'm still trying to find an answer for a paper that I'm writing right now. So I'm still a bit like confused, which is the correct way to follow. But this is unfortunately the pessimistic scenario that we have at hand.
Definitely. Thank you. Unless Rosanna or Ella want to add something to this, I wanted to introduce also the added difficulty of, even if you entertain the hypothetical scenario that you can produce such compliance, or that you can enhance the protection to cover these aspects, then you still have to address the fact that these are private companies operating from the US, where enforcement would be even more difficult also on a global scale. And again, going back to the findings that we had from the interviews that we have performed so far, what emerges as a common denominator also in regulating that space is essentially, well, consent, but consent through the terms of service. And so the way that these private companies are self-regulating does also determine to what extent they would cooperate with different law enforcement across the globe, and they get to put the context, right? So they would say that they want to only collaborate with these types of cases, or they only define such a case if, for instance, someone has indeed died and not, for instance, severely injured, or and these are of course all criteria that are quite arbitrary and are determined by the kind of the user base, general sentiment. And by listening these stories also again and again, it appears as if these private companies do actually hold an ever-growing power in determining how law enforcement is going to be developed in the future, and these practices also just insert themselves into being created as necessary infrastructures for policing across the world. And so after also listening to Ella's introductory remarks on how already let's say the well-regulated police databases are presenting all these issues, then I wonder, what are the types of checks and balances that could be introduced to address these power relations that are emerging between users that are also citizens, and between law enforcement and the DTC private companies, and also all that under the purpose of serving the public interest. So I wanted to address this question to Rosanna, maybe, if you have any thoughts on this.
Yeah, well, that's a famous $1 million question, in the sense that, well, as I was mentioning in the beginning, the sector at the moment is largely unregulated. So at this moment, in my opinion, without an appropriate lawful basis, the use of commercial DNA databases for law enforcement purposes would be a controversial expansion of the existing DNA forensic databases, which are highly regulated in the EU. So if commercial databases will be used in the future for law enforcement purposes, a clear legal basis should be established, which should consider the appropriate safeguards, checks and balances, the appropriate risk assessment should be performed, for instance, also taking into account the appropriate security measures to ensure the data integrity of these databases. I mean, just think about that after, we still didn't have the time to discuss this, but for example, there has been a pilot case study in Sweden for investigative genetic genealogy, where essentially they tried to see whether it was possible to identify a perpetrator from a crime committed in 2004 using GD match. And after the pilot was concluded, after the pilot ended, just a few months later, GD match, these commercial databases, suffered 2 data breaches. So, but cybersecurity, I would say that perhaps is the peak of the iceberg. So it is one element that to be considered, but indeed there are other aspects that will have to be taken into account. First of all, the results obtained through investigative genetic genealogy, how accurate are they? So we have heard some success stories, like the Golden State Killer that has been identified in 2018 thanks to the use of commercial DNA databases. But is this a representative sample? And also, what are the costs of using such services? I mean, costs in terms of money, time, effort, people, specialized geneticists that have to be dedicated to this task. Second, the use of commercial databases for law enforcement purposes should pass the test of necessity and proportionality, and some expert groups, such as the UK Biometric and Forensic Ethics groups, have already expressed serious doubts that this would be the case. Another problematic aspect that I would like to stress in this context, it is that there is a potential in this case to create a system for large-scale remote identification in an online space. In addition to this is going to be based on the consent given by people who joined a platform created essentially to reconstruct your ancestry, your family tree. So we can say that the purpose was essentially leisure. It is true that platforms like GDmatch or Family Tree DNA ask users to actively consent to law enforcement uses. But I mean, this is a long-lasting problem that people investigating law and behavioral sciences know very well. So how informed that consent is? Who has the time to read the terms of services? Are those terms of services clear enough? Is it clear what are the risks? So that my sister could be implicated in a crime investigation. What happens if the terms and conditions change? You usually receive an email, and imagining that it's not going to end up in the spam. Again, who has the time to read that email and then take an informed decision to change, for example, the privacy settings? And as was mentioned earlier, how freely given would be the consent? Again, I can consent for my sample, but I'm also consenting for my whole biological family, the existing one and the future one. Finally, we have to bear in mind that the majority, if not all, of these databases are established in the US. So it's a system which is where the European Convention on Human Rights does not apply, and US laws on surveillance have not been positively evaluated by our Court of Justice. So we should need to consider, on the one hand, how the users in the databases are protected, and on the other hand, we have to solve the conundrum of exporting extra EU sensitive data, which is going to be, the biological sample that have to be uploaded on the server. So all in all, there are a lot of problematic points that will need to be addressed and just from a legal point of view.
Yes, definitely. Thank you for this. More questions than answers, which is usually the case after I finish an interview for this project. So yeah, I have one last question for Ella before I open the floor for questions from the audience, because we have already discussed a little bit about the inability of simple data protection compliance checks in these types of collaborations. So I was wondering if you, from your perspective, from your experience, could give us any other perspectives on regulatory governance, et cetera, that would bring this necessary opening of the regulatory space to better engage with these genomic identity markets.
I think before we can even get into that space, there's a pre-step at a societal level that we really need to interrogate. When I was preparing for this panel, and I'm really sad that Amade wasn't here because the race and genetics element really stuck out to me. I was looking on Ancestry.com, and they talk about having a DNA experience when you use their site. And they also have been promoting that they've recently improved the accuracy of their ethnicity estimates. So it's all focused around this, to me, quite a bizarre idea that, I can understand the appeal in wanting to understand your heritage, but at the same time, commodifying and commercializing your identity and focusing on this stratification of people into smaller and smaller boxes. We see this in our kind of broader biometrics work as well. We've seen there's a Spanish company that offers remote biometric identification and categorization that does racial profiling for security purposes. And we challenged them about it, and they said, oh, we would never sell that into the EU, don't worry. Because, of course, it's okay to discriminate against people from third countries. But, this desire, this compulsion to put people in different boxes, I think really, really concerns me, because you look at, back at history, what regimes started with people being stratified on the basis of who they are, on the basis of things like the shape of their face, different elements of their profiles. And I think there's a very dangerous impulse that underlies this that you probably have no idea about if you think it's just a bit fun to go and see your, ethnic background, to see what allergies you might have. Which, I think it's, again, that's a bit bizarre that you would need that to tell you what allergies you have. But yeah, so I really think that we need to kind of collectively think about what our boundaries are, what it means to become a genetic template or a biometric template in a massive database, whether we reach a point where there's so much data gathered about you from social media that can combine with all these different data. At what point does that start eerily resembling you to the point where we need to think about how we deal with that? And it's not just in this kind of stratification. We're seeing AI-based experiments with bone testing and dialect prediction against migrants and people on the move. The EU really focuses a lot of this innovation and research into profiling people in different ways at the borders against people who are being put in this vulnerable position. So I think we need to, think about what we actually want before we can then find a coherent regulatory framework. I think there's a lot right now already that helps, and there's a lot of gaps that are being filled, hopefully, in the EU's AI Act, maybe being weakened again with the PROM framework. But yeah.
Yes, exactly. And this is also another big question mark, which unfortunately we cannot answer because we do not have the expertise. Amade was going to elaborate a bit more on this, but for me, what I found problematic is also this, this presumption of accuracy on these profiles, or the goal that we're trying to achieve. We have this idea that with more these more intensive and more micro datafication of the most substantial elements of ourselves, with this micro categorization of all different types of features that we might lead us to a better understanding of who we are, or a better representation of who we are, better representation of the world in the digital, right? And I think that this is where this misconception begins. and the level of trust that we would put on these types of results, especially when it comes to law enforcement practices. And so on this positive note, I wanted to open the floor for questions. I wanted to, gather a couple of questions so that we don't have to go back and forth. One. Yes, two, and three.
Hi,
Let's
I'm
do three
Andrietta.
first and see. Hello.
Okay, I have a question regarding using platforms such as 23andMe and all these other ones. I find the nature of it, I think, coming back to thinking, reflecting on it, there's an opportunistic aspect of it that doesn't take into account that some people are actually trying to find their ancestry because of slavery and things like that. Yes. And you find collaborations with other platforms like Airbnb come and have your experience here, like it's entertainment. Wouldn't you agree that it's not so far apart from a dark pattern, even if maybe it doesn't fit the pattern, the definition we have right now, because there's an opportunistic and deceptive aspect of it that says, oh, I'm trying to help you find a belonging, but actually I just want to harvest your data and the one of your relatives. And the second question there is around the notion of control. Where does household exemption come in when it comes to this? Is my cousin taking the test, becoming a data controller, because we cannot say it's really limited in terms of the impact it can do?
Thank you. And in the back, and here in the front.
Hi, thanks a million for all of this incredibly interesting info. I just wanted to ask, to what extent do you see it being on a continuum with existing forms of profiling? Ella already brought up this use of biometrics to categorize people into ethnic origin or race for surveillance purposes, but we also see more complex inferences coming. And I know my partner's brother did this completely baseless rubbish genetic test to predict his muscle, athletic potential performance and what types of food he should eat. So I'm quite interested in these more complex forms of prediction and categorization. And I think we also see this, for example, in, say, virtual and augmented reality, that we'll have, again, more and more granular data that, as you said, is based on the myth that the more detailed the data we have, the better the predictions are going to be, which is not true, because if the theories are crap, the predictions won't be any good, no matter how much data we have. But to what extent is that on a continuum then with existing forms of profiling, things like eye tracking, or is there something very particular in the genetic data? It seems to me maybe that because I, as a third party, have some kind of ownership over the genetic data, that I maybe have more opportunity to protest against the profiling based on someone else's data, rather than if I'm seen as a similar category based on the way I behave on the web or things like that. And do you see any legal avenues of resistance that are possible? Because I think a lot of the avenues that we see are based on identity, but I see an awful lot of harms coming through these profiling type things that are categorizing us.
And here in the front.
Thank you. When you talk about access by law enforcement to the commercial database, do we make any distinction between crime prevention purposes and crime investigation purposes? Do you think there are any differences in accessing this tool, or do you make any at least differentiation or focus in your research? And a related question is, if we are talking about crime investigation purposes. So in prevention, for instance, do we talk about indiscriminate access to all databases without differentiating a certain aspect? a suspect, sorry. And for investigation, then maybe we have already some evidence that a person might be committing a crime, and we summon the company to only access the data about that specific suspect, let's say, or their family members or biological family members, and assuming that depending on the country, the procedural law might allow to access might allow summoning the documents, the health information, the DNA of a certain specific suspect or their family member, depending on the situation. And there, other than consent, we actually might find a legal basis based on the national law that we actually can have access to this or retain this data. Then would you still find a problematic thing there? A legal basis other than consent, but would you still find it problematic that we actually have access to that data? Thank you.
Okay, so I want to start with the order that the questions were asked. So first you asked on the different narratives that are used as marketing pitches to get people's data, right? And indeed there is this trend of empowerment that is sold by specific companies to specific populations. For instance, in the US, specific companies would sell this a promise of, well, I'm going to help you discover where you come from. I'm going to give you, all your origin in order to get that data. And there's a lot to be said where, you create you create a semi-exclusive database of people coming from specific ethnicities, where it can be used, repurposed for other practices, also specifically with law enforcement. So definitely, I would say that this is very much a misleading practice in that sense, where you want to instigate this. Commodification of this specific narrative to enrich your database, and then make it more valuable by giving all these different privileges to law enforcement. And then you asked about what is the level of influence that might the household exemption might have for these protections of genomic data. And for this, I would like to pass to Tanner maybe to answer this question.
Yeah, sure. Well, for the data protection lawyers here, #save me if I do a mistake here, because I need to refresh some of my memories about the household exemption. So the thing is, for the ones who are not lawyers, a crash course on household exemption is that GDPR doesn't apply certain type of activities, and one of them is that if that processing activity relates to a personal or household type of activity. But of course, not unsurprisingly, we have a lot of debates like what is actually household, what's purely personal or household activity. So this is exactly one of the points that actually comes into play, as you briefly mentioned. It's one of the places that we cannot actually define whether that is a personal activity or not, because according to CJU case law, I'm really struggling to remember the name of the case, but according to CJU case law, if you publish an information to an indefinite number of people online, so it's not anymore a personal activity. So it doesn't fall. It falls under the material scope of the GDPR. So. Again, your example, let's use it. So I have my sister or brother, whoever, a biological relative, takes a genetic test, direct-to-consumer genetic test, and uploads it onto social media to his or her Twitter account, just for fun, or maybe finding some lost relatives, or to find a support group for the hereditary disease or whatever. But that account is not restricted. So it's actually accessible by anyone who has Twitter or anyone who has access to internet. So, and I have an interest here too, because that information is actually also my information too, because it's shared genetic information. So here we have lots of questions. Because again, remember the interpretation that I just mentioned. Am I also a data subject here? Because that information is relating to me, and I am quite identifiable because it is my sister's or brother's Twitter account, so I am identifiable. Of course, that there are some other tests here, but like briefly mentioning that. But here, if I say to my sister, take it down, can I do that? Or she really needs to take it down because she also has a legitimate interest here, like by putting that information out there. So actually, this debate was covered in one of my upcoming papers, and I really appreciate it if you read it. But yeah, it was really like refreshing my memories too. But again, as I said, that apart from that self-promotion, so here we don't have any questions that are like definite because we have competing interests, and here again we introduce that. Crashing, like a stress test for the GDPR that crashes down that binary and individualistic protection scheme. So I don't know how CJU would answer to your question.
And on the second question that the person in the back asked on profiling, right? So this is something also that I kind of entered this discussion, this research with these types of questions, like whether it would be profiling, and specifically on the examples that you mentioned so well, you know, that there are more complex inferences on, even more than your ancestry. I wouldn't, to the degree that I understand the way that they are providing these profiles, I wouldn't call that specific type of processing related to, you know, part of the genetic data, you know, category, because it is already, as you have said, like it is a much like secondary product that is very much a product of their quite obscure criteria that they use. They claim to, you know, consult the latest scientific research, but I really don't understand what that means when it comes to, you know, your athletic performance, your like inclination to playing the piano or something. So they do claim that they have some scientific value, but that is quite intransparent and very much skewed. And so I do think that these types of cases could fall under these the category of the categorization as, you know, specific type of profiling that is happening, and then the relevant GDPR articles would apply in these cases, but not as profiling based on genetic profiling. I wouldn't call that genetic profiling because it's so far removed that also, I mean, maybe it is misleading practices to promise that, but also I don't think that it has any link to the actual DNA profile that they are producing. And finally, to the last question, because we only have 5 minutes, and that was 3 minutes ago. So you asked about, when we talk about law enforcement access to this private database, whether there is a distinction between crime prevention and crime investigation, and or whether this is indiscriminate, and like what other types of lawful means to access these databases besides consent, because consent obviously doesn't work, right? So. One small point, because I opened it up, again, based on the findings of our research, that, well, it is actually the private companies that do determine the context. So they do, so on these interactions in these specific projects, right? So it is the private company that's going to say, these are the types of cases, these are the types. And usually it is crime investigation. It is purely on this ex post situation. So it hasn't really been, I haven't come across any type of case that was for crime prevention. And maybe for consent or any other types of means of processing? Or
I mean, I could mention a little bit about some of your questions linked to what we're seeing in the PROM2 framework that I mentioned, which is an issue called forum shopping, where even in the existing PROM convention, PROM1 that's been around since 2008, we see sometimes in the course of criminal investigations, law enforcement looking for the participating country with the lowest rules on a particular type of data, on a particular type of activity. And because this is a set of rules that allows that kind of exchange across countries, the law enforcement will go to the country where there are the lowest rules in order to, benefit from the fact that they aren't as restricted in country X as they would be in their home country. And they're also proposing to have a kind of constant automated matching of all DNA profiles that are accessible through that system. And so to my earlier point about how we have a lot of skepticism about the DNA and other types of sensitive data that's already held in a lot of these national databases, these really systemic failings, is that individualized suspicion on the basis of serious crime? I would say absolutely not.
And Rosanna, because you're online and you can
Yeah,
see
sorry.
us also, I wanted to directly kind of give the mic to you in case you want to intervene in any of the questions or have any additional
Yeah,
points.
no, sure. I can just briefly comment on what has been already said. So regarding the household exemption, I totally agree with Tanner in the sense that I think that at least in the example that was mentioning earlier, the housing that is uploading the DNA, hair DNA on Facebook or whatever, what are kind of platforms. I think that in that case, since there is a sharing with a public, with a huge number of people, in that case, it would be very difficult to rely on the household exemption. It is true, however, that if we look at some genetic databases, it is possible to customize the access level. But again, we go back to the $1 million question. How many people are really aware of this possibility, and do they really understand the risks or the implications of their choice? I mean, the good news is that if we don't have the household exception, the GDPR will apply, but then again, we have to solve the other issues. So we have competing interests on the same piece of information, and which one should prevail? So which data subject should have the definitive answer? There is, just one case, the Novak case, that is about the same piece of information that is shared by different type of data subjects. In this particular case was about the evaluation of an exam. So the evaluation done referred both to the examiner, and it was also information related to the candidate. But again, I'm not sure how the situation will, for sure there will be a different balance of interest when we are talking about genetic data. So I'm not sure to what extent we could expand that line of reasoning. And there was another question regarding, whether, what the purpose precisely of law enforcement. And yes, I can confirm what have been already said by Alexandra. At least, as far as I can see, the majority of uses refers to crime investigation rather than prevention. And again, that there is the paradox in a way that what kind of crimes can be investigated and what crimes cannot be investigated, it is decided by the platform through their terms of services. So they are essentially establishing law for law enforcement, and they are also deciding which authorities can access their databases, from which jurisdiction, and which jurisdiction cannot have access. And so I was discussing this with Alexandra a couple of days ago, and Alexandra, I have to quote you on this because I think that this sentence is going to summarize very well what's happening here. So that through this private ordering established by these private companies, they are essentially creating an imaginary as law enforcement authorities should look like. So it is a trend that we are observing in many other sectors of the information society. So-called platformization is expanding to health, education, video conferences, work, housing, mobility, and it might be soon the case of law enforcement. And actually, the question that was posed is interesting because at the moment they are considering crime investigation only. What if they will consider crime prevention in a not too distant future? So I think that it's something that we should start asking ourselves. It's a question that we should start asking ourselves.
Thank you so much. I think we're out of time and we're very much on time. Yes? Yes. Thank you very much for coming and for staying and for your questions. And looking forward to more. Come talk to us and yes. Thank you.